Dear friends, welcome back. Once again, I am your friend Ashok Rajguru, and this is the second video or lesson 2 of module 9. And in this video, we shall be looking at the Competition Act. This act was passed back in 2002, and it was supposed to replace the Restrictive Trade Practices Act, the MRTP Act, in order to promote growth and improve competition to the advantage of the consumer. Very briefly, what it does is that it protects the consumers and prevents market distortions, and it promotes efficiency and economic growth. So the keywords here which concern us are protection of the consumer and prevention of market distortions. And by the time you finish the third lesson in this module, you will understand how to apply the law in order to protect our interests. As I mentioned earlier, the Competition Act was passed in the year 2002 and it came into force in January 2003 to protect the consumer. In the month of May year 2009, the concept of dominant position abuse was introduced and legislated into it. And this is what is going to concern us to a very large extent when we are doing an analysis of the conveyance deed draft. As a matter of fact, it also applies to the agreement to sell which each one of us has signed at the time of buying the flat. In essence, this act created a new body called the Competition Commission of India, which is a quasi-judicial body. It can pass rulings and it has the force of law. The only way to challenge their judgment is by another body which was formed as a consequence of this act, and that is known as COMPAT, or it means Competition Appellate Tribunal. So it's the body that is available for redressal of any appeals against the ruling of CCI. And what is interesting is that the judgments or the rulings of the COMPAT can only be challenged in the Supreme Court. So this act has done away with a lot of litigation where it would take many years in order to come to a fair application of justice. Now, what does this Competition Act do for us, the consumer? In essence, what it does is it covers every agreement. And by agreement, it means anything that has been mutually agreed, either in writing or even verbally or even informally. It extends the definition of agreements to even a wink and a nod. So that is something that you must keep in mind. The next thing it does is it prevents abuse of dominant position. When you were buying a house, did you have any choice in order to get any word in the agreement to sell altered? No. You simply had to sign on the dotted line. Regardless of whether the content was in order or it was defying any law, you simply had to sign it. That is what is known as a dominant position, where the seller can force you to sign some clauses which go against the law. And we shall examine what those provisions are. Another important point is that it disallows any tie-in agreements. In other words, if you buy this product, you have to buy these services or you have to buy another product. For example, if you buy a car, the car seller forces you to tie in a service agreement for a certain number of years. We shall look at that shortly in the later part of this lesson. So any kind of a tie-in agreement, whether that is regarding purchase of another set of goods or for services, is simply disallowed. Now we'll take a look at what is meant by a dominant position. A dominant position is a position of strength enjoyed by an enterprise, which means a company or a builder, in the relevant market in India, which enables it to operate independently of competitive forces prevailing in the relevant market. Each one of us is a buyer of a flat in Athashri, and Athashri is meant to be an abode for senior citizens. There are very few choices available to us which will suit your budget, your location, and your requirement other than this particular supplier in the market. What exactly is meant by prohibition of dominant position? What really is meant is that any action which limits or controls the provision of services. For example, if you tie in an agreement that these flats will be serviced, maintained, or any such service will be provided by one and only one organization, then you are in violation of section 3 bracket 3. Similarly, any form of a tie-in arrangement which requires the purchaser to buy some other service is also strictly against the law. Looking at section 4, it imposes, if any condition imposes conditions in the purchase of goods and services, once again that's a violation and that comes under the ambit of dominant position. Now how does all this work? You have already signed the agreement to sell. Can we go back on that? Well, each one of us can take that action but need not take that action because now that matter has come up at the time of the conveyance deed, which we shall see in the next video. Any individual or a Hindu undivided family or a cooperative society and many other entities can make not a complaint, but that thing is known as an information. There is no complainant, but there is an informant. So for instance, if I have to make a complaint, so-called, I would be considered an informant to the CCI, to the Competition Commission of India. What happens next is I apply my complaint or my information on form 1 if it's a short issue. For long matters, there is a form 2 which is also available. If it's a very detailed matter that requires some expert consideration, the CCI can initiate an inquiry through a Director General. Now, we are often wondering whether these cases are disposed of soon or how long it takes. Is there litigation required? As I mentioned earlier, in case any investigation is required, that is done by the CCI through the Director General. And here is a quick record. They are very quick in disposing of cases. 79% of the cases, that means almost 4 cases out of 5, have been decided within 30 days. 19% of the cases have taken as long as 60 days. And only less than 1% took 120 days or 4 months. There is only one case which took more than 120 days. So this is not something that is going to be lying in courts for years and years and for generations. Cases are disposed of immediately. And as we saw earlier, any appeal to their ruling is done by compat, which is the appellate tribunal, and after that it is straight away challenged in the Supreme Court only. There are no intermediate courts that can handle these cases. Another important thing to note is who is punishable. Suppose there has been a violation or there has been an abuse of a dominant position, then who is punishable? First of all, it is the enterprise which is doing the abuse of dominance. There can be a fine up to 10% of the turnover, and we'll see how these numbers have been applied by the CCI in a number of cases. The directors and officials are also liable. This is a very important clause because if an agreement is signed by officials, that is office bearers of the society and the directors of the builder, then both of them together will be liable for any violation of a law under Competition Act. Initially, CCI will ask the concerned party to desist and it can impose fines. In case of non-compliance, then people can be sent to jail for up to 3 years and can be fined up to 25 crores or both. And that applies to directors and officials also. So it's a very strict condition, and that is how they have been able to enforce this law very efficiently. The question that comes to the mind is, does it really work? It sounds so good, but is it effective? Let's take a look at some numbers. 72.96 crores, that is almost 73 crores, had to be paid by Lupin Pharmaceuticals for violation of clauses relating to dominant position. 257.9, almost 258 crores were paid out by three airlines together, Jet Airways, Indigo and SpiceJet, because of cartelization. They were trying to fix prices in connivance to the disadvantage of the passengers. 630 crores were ordered to be paid by DLF, a real estate developer in North India, for a property which they developed in Gurgaon. Once again, dominant position abuse. And this is a very big number. This is 2,544 crore rupees. And this was paid out by 13 car makers for dominant position abuse. This particular case was fought by a single individual who was a dealer for Hyundai Motors, and he had put up this case against 13 car makers because they were following similar policies. And what were the policies? They were relating to restrictive practices of not allowing sale of their spare parts to the open market and tying in a service agreement or a service contract on the customers. 13 car makers including Volkswagen, Mercedes-Benz, Tata Motors, Honda, Hyundai, you name it, and they were involved in that. Once again, I am repeating the number, 2,544 crores. So it's not a case that if you are fighting against a big powerful lobby, you are going to lose the case. No, this last case which I mentioned was a single individual who was just a minor player. He was a dealer of spare parts for Hyundai Motors. And as I told you earlier, these cases are disposed very fast. Of course, in the case of this automotive car manufacturers, the Director General took about 9 months to finalize the report. And as we have seen earlier, 80% of the cases are disposed of within a month. This brings us to the end of this lesson, and we shall summarize the points that are covered. Most important thing that applies to us as far as the conveyance deed is concerned, under the provisions of the Competition Act 2002, you cannot tie in any services and that will be considered as an abuse of dominant position. The CCI, Competition Commission penalties are very stiff and the justice is very quick. It doesn't matter if the case is against the high and mighty, as we have seen, all the big names in the automotive industries, pharma industries, even government agencies, MSEDCL, Coal India Limited. What I would invite you to do is to go on their website. A link has been provided in the additional resources section, and they have a quarterly journal, a quarterly publication where they give a summary of Section 3 and Section 4 violations which apply to us. You'll see all the big names of companies, and very often the people who are the informants or who were aggrieved were just ordinary people like you and me. Let me remind you once again what we saw in the previous video, the first video in this module. According to the Indian Contracts Act, Section 23, you cannot include any such terms which would contravene any law in India. In other words, private contracts cannot curtail public law, even if the contracts are between two mutually consenting parties. Thank you very much for your attention, and then in the next video we shall meet again and look at some other provisions in the conveyance deed, and you will be able to make a judgment yourself. Once again, thanks very much and bye-bye.